Thank you very much, Stefan. Yes, what I should say about Giovanni Sartor, he's a real guru in our field. He knows the people, he knows the library, he knows everything. And this since about 30 years. Actually, we have something in common also. We're both professors. He's the most successful one. He's in Bologna and in the European University Institute. He's also heading the very famous research institution, the CIRSFIT in Bologna, founded by Pataro. I have only a small boutique group here in Vienna. We both have some affiliation to the European Union. He was started there as a young researcher, translator, and then moved later to science. I also have some activities there. But besides that, Giovanni is an organizer of our community. He's also a professor, but that's for the practitioners, not so important. So he knows the field, and he's always working with projects, with his students, also from the European University Institute, how to improve and how to help people doing law. And he's also a quite famous legal theorist. So his aim is always to improve the law as such, also within the theory of the Austrian Hans Kelsen. That's also some kind of a guru of the institute in Bologna. Today he will speak about ontologies. I'm very interested in what he would like to say, because ontologies on one side, and he is an expert in legal logic, how both can be combined, how they work together. And Giovanni, after so many years, he may have some ideas. Sure, he knows what has happened, but still, how to develop, how to move on. This is the topic of our conference here, and I'm quite sure Giovanni has some ideas, and he's a good speaker. Therefore, Giovanni, you have the floor, and we are looking forward. What do you have to say?
Okay. Thank you very much, Eric. Can you hear me?
Yes, I can hear you.
Okay, so I don't need to put on the ear cuffs. Let me share the screen and get started with my presentation. First of all, I would like to thank you very much, Eric, for this introduction. We have been working together for many years, since both of us were quite young, and time has passed, but we are still here discussing issues of computers and law. And the discussion has been changing a lot during the years, but there is some continuity. So let me share my screen. Okay, share, and let me see whether this works. So like that. Okay, let me go to the beginning of my presentation. Is it working? Can you see my presentation? Okay, so I will in my presentation, I think I have half an hour more or less, isn't it, Eric? Where I will try to introduce, and then we'll have a discussion, some concepts, some ideas pertaining to legal ontologies, how they developed through the year. I will also make some reference to legal history, and maybe also to Kelsen or some of his friends. So ontologies play an important role in modeling legal knowledge. We have legal sources with terms. We have legal norms that express somehow the prescriptive rules coming out of those terms. And then we have the concepts within the norms that are expressed by the terms. How are these aspects connected? Let me give you an example that lets you understand also the importance of concepts in the law, and consequently also the importance of concepts. Now we have the GDPR that at Article 4.1 says that personal data means any information related to an identified or identifiable natural person, data subject, and then an identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier, and so on and so on. So here we have a section in the GDPR, a very large section, section 4, that deals with definitions. It introduces concepts, and then these concepts are used in the following articles of the GDPR. So what is the legislator doing when specifying these concepts? Obviously, we can capture, we can provide different accounts of Article 4 in the GDPR. The legislator is telling us the meaning of the term personal data, or a meta-linguistic formulation. The legislator is speaking about a term, or the legislator is telling something about an entity, personal data as an entity that exists in the world. Or we can see what the legislator is really doing is that the legislator is issuing rules. We would say they are not directly so-called regulative or prescriptive rules, but there are, you can say that they are count as rules, or rules that constitutive rule. This also is terms, they are said. So one of these rules may be if and only if information concerns an identified or identifiable natural person, then it is personal data. And if information consists in an identifier, then it concerns an identified or identifiable natural person. So we have a concept, and we have three ways of characterizing it, basically. We are speaking about a term, we are speaking something about somehow a legal reality, or we are issuing rules that tell us how to ascribe certain property to certain entities. So what are we doing? What are we doing when we are discussing a legal term? Why are we discussing the meaning of legal terms? And what are we doing in legal informatics when we are trying to capture the meaning of legal terms? So this is the kind of general issues that I would like to discuss with you in my presentation. We can view these also as partial, not necessarily in legal text. We find if and only if definition. We can also have partial definition that tell us that something is included in a more general term. It is important to note, before going into the discussion on how concepts are represented in legal informatics, that there is also a normative side to legal concepts. When we use legal concepts, this was an idea that was made popular, as I will say later, but by a legal theorist, Alf Ross. We are really speaking about what follows from these concepts. So usually we have two levels. First, we say that if certain conditions exist, then a concept applies. But then we have that if the concept applies, then some normative consequences follow. So when we are arguing for the inclusion or for the exclusion of some entities in a concept, we are arguing also indirectly for the application or not of certain legal consequences to that entity. And here is where teleological reasoning goes into legal concepts. So we may wonder, for instance, whether the concept of personal data also includes evaluations concerning the data subject. This is an issue on which there is a lot of uncertainty in data protection law. Consider, for instance, competition or an appointment. The committee concerned with the appointment will make comments, evaluation on the skill, of the competence, on the character of the candidates. Obviously, if these evaluations are considered personal data, then the data protection regulation will, the GDPR will apply to them. which means that the data subject will have the right to access this kind of information, and so on. If, on the contrary, these are not personal data, then the obligations and the rights that apply to personal data will not concern evaluation on other people's character, attitude, and so on. Another example that gives you the importance, the normative importance of concepts. There was a big discussion in the past years whether some very, they say, strong methods for extracting information for people, such as the so-called waterboarding, what people will put under the water in order to coerce them into confessing, were to be considered as an instance of torture. Obviously, whether or not waterboarding is a torture, is a kind of torture, makes a difference, because if waterboarding is considered an instance of torture, then it would be a violation of a human right, and the human right not to be tortured, that has no exceptions to it. At least this is how it is usually understood. So if waterboarding is viewed as an instance of torture, then it would be illegal. On the contrary, if it is viewed as a kind of strict or strong or intrusive investigation method, then under certain circumstances, it may be okay. Another interesting issue concerning classifications, to give you the importance again of this idea. There has been a big discussion whether social networks and the social networks company are host providers. Obviously, if they are host providers, then this would trigger the liability exemptions for host provider. If they are not host providers, then they the e-commerce rules on liability for the behavior of their users, on secondary liability, will not apply to social networks. So within the law, concepts, let me say, are not neutral, in the sense that by considering or not that a concept has that the contents applies to certain entities, then these entities are included or excluded from the legal discipline that applies to the concept itself. There is also, so we have a normative problem that underlies the use of legal concepts. And then we have also the fact that a concept may appear in different legal sources. So we may wonder to what extent the same conceptual meaning is appropriate for all of these sources. And here we have the kind of teleological consideration that I mentioned before. Maybe it is okay to understand a term in a certain way, in a certain context, given the regulatory, the normative effect that are connected to the classification in that context. Maybe not in another concept. What can be viewed as, for instance, as a consumer with a purpose in connection with a certain law may be different for what should be considered as a consumer or as a professional in the context of a different legal regulation. To what extent the same term in legal documents may be understood are referring to the same concept. So we may wonder what is the purpose of the legal ontology, given that legal concepts have these features. They have this kind of normative, of teleological perspective. They trigger legal effects. And secondly, also given that the same term in different documents may have indeed different meanings. So there are two and a kind of conflicting objectives: capture the law with its nuances, but also preserve internal coherence and having a general scope. Another issue that pertains to the history of legal theory concerns to what extent the conceptual specifications that are included in ontologies, in characterizations of the meaning of legal concept, express legal norms, and to what extent these norms are reliable. There is a history of discussions on conceptualist approaches to legal domain that this is not the place to consider. Let me just mention that the author that tried to reduce concepts to norm, the most cited author is the Danish legal theorist Alf Ross, who had the idea that legal concepts do not really have meaning. They are, their purpose is just to simplify the formulation of the law by linking set of conditions for obligations and permissions that had similar antecedents. In Ross's example, it happens in a tribe that whoever eats the chief's food, whoever kills totemic animals, and whoever meets his mother-in-law has certain negative consequences. These are considered bad things in the tribe. It has to be purified and is forbidden for participating in rites. At a certain point, in the theory, in the tribe, they have the idea to invent an intermediate concept. They call it tutu. And now they start saying that whoever eats the chief's food, whoever kills totemic animals, whoever meets his mother-in-law, he is a tutu. And being a tutu means that this person has to be purified and is forbidden to participate in rites. And the normative consequences of eating the chief's food, of killing totemic animals, of meeting one's mother-in-law do not change. Each of these situations entails the obligation to be purified and the prohibition to participate in rites. But we obtain a simpler representation of normative knowledge thanks to the use of intermediate concepts. This is an idea that is connected also to some discussion in the philosophy of science on the role of concepts within scientific theories. And if I remember, I don't remember, no, anyway, I don't remember the authors now, but there was a discussion at that time in philosophy of science, and even before that, on this use of concepts. Ross interprets in a similar way also the concept of property. So it has no meaning by itself. It is only used to connect multiple circumstances in which we acquire certain sets of rights to these sets of rights. And so the concept of property has no meaning in itself. It only serves to simplify the presentation of legal norms. Following this kind of inferential approach to concepts, it appears that concepts can in a way be reduced to legal rules. The ontology is just something that comes up from the legal rules that are used within a certain legal system. On the other hand, we have traditionally had in the legal doctrine a lot of conceptual definitions and classifications. And this is also what we find in today's computational ontologies. Just to show you that this is not a new thing, let me go through some classification that can be found in quite ancient legal sources. This is the well-known conceptual architecture that can be found in Roman law, in the Institute by Gaius, which this concerns persons, but then there is also things and actions. These are things quite similar to what we do also today, even though no, obviously we don't distinguish between slaves and free people, but this is a great German jurist at the source of modern civil law, and is in the inventor also of private international law, so a key figure in legal history, who also proposes an interesting, we would say, an ontology, a classification of entities that fall under the law. This is another leading German scholar of the 19th century, which also proposes his classification. And so for both these authors, you have the legal rules, but then the rules speak of certain entities, and then of these entities, you provide an account through definition. Another famous German lawyer, German legal scholar, Winscheid. He has the legal rights, where again you have classifications. Then you have a classification of things. So the idea is that to link legal rules to concepts, and assuming that each entity, as distinguished by this concept, is characterized by a specific regulation. This is a recent Italian lawyer, comparative lawyer, quite well known, who also has proposed his own ontology for the law. This is an American legal scholar who is Roscoe Pound, who also was following this kind of conceptual ideas to organize the law based on a set of concepts, but then he changed his mind, and this is how Winscheid organized the legal knowledge according to Pound. At a certain point in legal thinking, let me go on. At a certain point in legal thinking, there was resistance against this way of organizing legal knowledge, that is assuming that you have a fixed set of concepts and each concept is associated to a specific regulation. We had a more, I would say, norm-based or teleological approach, showing that you could maybe associate rules to concept, but then there was exceptions. You had to take into account purposes. And this kind of discussion, I think, can still be relevant to the development of legal concepts in within legal informatics, which is what I would move into now. I have mentioned this background because I think that it is important that we know that when we speak about legal ontologies, there is a background to be taken into account, both in favor of organizing legal knowledge through a conceptual framework, but also as a pointer to the limitations of this kind of approach. And in particular, how how the way of organizing legal legal knowledge based on concepts can be in conflict with the organization of legal knowledge based on rules and on the rationale that underlies such rules. We had various ways of representing legal knowledge that have been developed within research on legal informatics, and in particular within research on AI and law. We have, first of all, we can organize legal knowledge as rules, and logic programming has provided a kind of standard for this kind of approach. And we may say that logic programming adopts an approach to legal concept that is somehow related, I would say, to Rossi's approach of seeing legal concepts are playing an inferential role. So we have a set of rules that trigger intermediate legal consequences that on their turn they trigger further legal consequences, and we need to organize the system in such a way as to obtain the right duties and obligations in the end of our inferential chain. There are also other systems to provide this kind of reasoning, as in legal expert systems based on rules. This is a commercial product, this Oracle Policy Automation, then allows you to organize knowledge in this way. Legal concepts are the consequences of legal rules that may trigger further consequences in their turn. So this would go into the kind of approach that I have exemplified with Ross. There are various problems with rule-based expert systems in the law. I will not go into this kind of problems now. Then in the representation of legal knowledge, since various years, the interest has emerged for combining the representation of concepts through rule with the representation of concepts through an ontology. That is as a set of interlocked definitions. You can express definitions also through rules, but it has been argued that having a separate organized representation of concept through what is said an ontology, through a conceptual representation that usually goes from the more general concept to the more specific ones, is a useful way to organize legal knowledge. So we need the rules, but what the rules speak about can be structured as concepts. This corresponds a bit to what has been always done also in legal science. We have rules, but these rules deploy concepts, and these concepts are somehow organized into a structure that goes from the more general to the more specific one, and that exemplifies also further relations between concepts. There have been various attempts to develop ontologies in the law. You may distinguish between so-called light ontologies that are basically limited to relations between more general and more specific terms, and other ontologies, bottom-up ontologies that are built from a legal text, and other ontologies that instead use maybe some more general kind of information about the structure of reality, and that try to bring that down into legal specificity. So this here is an example of an ontology that deals with personal data processing. And then we have above foundational ontologies that specify the most general terms, such as what is a state of affair, what is an object, what is an event, and go down into the legal reality. We have also had the attempt to capture through general legal concepts, such as the Hofeld theory of legal concepts, which express the various normative positions that a person may have toward other persons. And this may be seen as a part of a logic for legal concepts, or as an ontology, a set of related concepts. Okay, then speaking about ontology, we get also into the semantic web, the idea of putting computer-readable information into the semantic web. And there as well, ontology play an important role as a way of indexing content, documents, and information according to its content. I also skip over this, and I move to another way of characterizing the contents in legal domains, which is also related to the idea of an ontology. There has been an important line of research in legal thinking that is the idea of argumentation, and the attempt to model legal reasoning through argumentation. The basic difference between modeling legal reasoning through argumentation and through a logic is that in argumentation you can have arguments and counter arguments expressing both general ideas and exceptions to them. What about ontologies? I think that there is a connection between argumentation and ontology, because if you see legal concepts in context of argumentation, then this may be important when we represent concepts, because then we may have concepts, consequences of them, but also exceptions. So you may have, for instance, that the idea of a contract may entail, or the idea of a personal data may entail the power of the data subject to access the data, but then you may have an exception to that. For instance, if the data expresses a kind of evaluation on the character of the person, you may have an exception to that. So having, and the same, you may say the contracts are generally bilateral, but then there are some instances of unilateral contracts. So in this way, you can somehow combine the possibility of having general concepts with the recognition that the effects that the law links to these concepts may encounter exceptions under certain conditions. So I would say that the recognition of argumentation and divisibility makes concept, enhances the possibility of capturing legal concepts through conceptual structures, since it includes the possibility that exceptions and arguments to the contrary are taken into account. An example of concepts can also be found in within case-based reasoning. This is taken by the Cato system that was developed by Kevin Ashey together with Vincent Aleven in some years ago, and which is still a model that is much commented and discussed, where you have, in this case, the concept of misuse of trade, that is characterized by a set of factors that push towards having these concepts and exceptions to it. Okay, then so let me sum up what I have been saying. So in the law there are these there is this trend. There are rules as a basic element of the representation of legal knowledge. Then we have concepts. Rules play a key role following Kelsen's approach. If we want to mention the great Austrian legal scholar. And then you have concepts. Rules use concepts, but the rules may also provide for exceptions to concepts. How to combine these ideas? We can adopt a rule-based approach to legal knowledge, where also concepts are characterized as rules. Or we may have a kind of hybrid approach to representing legal knowledge, when we have both rules and concepts which may be represented by using a different formalism. We can have concepts which allow for exceptions, and there we have argumentation and defeasibility. Most recently, so in an argumentation perspective, a concept is represented by a set of supporting arguments in favor of the application of the concept, but also by a set of attackers, negative conditions for the consequence of the concept. And even what follows for the concept, for instance, the obligation to comply to a contract, or the validity of a contract, may be subject to exceptions according to the structure of legal argument. Now we are in a different, we are entering a second wave of computable law. We are moving from the human representation of legal concepts into the so-called machine learning approach, where machines are provided with data and somehow extract the information from it. Where do concepts end? Where are concepts within the machine learning approaches? I think my time is running out, so I try to be quick on that. Where are concepts? Here is an example that I take from Kevin Ashley. You have a set of data and you have algorithms, for instance, for building a decision tree. In this case, the rules and also so the concepts based on the rules, in this way the concept of bail, are extracted from the cases, from the instances of the cases, and the system learns a concept, learns when a concept has to be applied or not based on the cases. We may have also connectionist models of computing, when the concept is learned and the concept is a structure, for instance, of a trained neural network that has learned to recognize instances of bail or of not bail in this example. To finish, let me just show you a recent example that we have developed, a project in which I have been involved. This is a project that deals with automatically identifying unlawful clauses in consumer contracts and in privacy policies. So what the system learns is the concept of what is an unlawful clause or an unlawful clause in a contract or in a privacy policy. And we adopted the various methods to train the system. We used the so-called bags of words model, where each phrase is represented, each text, each clause is represented by a vector. Then the knowledge of the system is included in this set of vectors, and those vectors containing the same term would be the concept at stake. Or you may have the training may be done based on tree graphs, so where you have also the structure of the phrases, and again a concept will be represented by the set of the phrases that contain it. Or we tried to use also supported vector machines, where against there is a classifier that learns a function, and this would be the concept of unlawful clauses that the system has learned. We have also tried to make a more complex setup, where again the system is learning what is an unlawful clauses by combining the text and a set of explanation and connecting text as explanation. Where is the concept gone? It is in the combination of these representation structures and in the way in which they are modeled. I think I stop here with my presentation. I would like to thank you for your attention. Let me just summarize key points that I tried to express. Norms and concepts appear in legal reasoning and in legal documents from very early on. We have rules and we have concepts. Concepts connect rules and they have a normative significance, since ascribing a concept means to ascribe the legal effect that further rule connected to the concepts. We had from the very beginning of legal thinking the idea that you have on the one side legal rule and on the other hand a characterization of the entities to which the rules apply, that is the concepts. And in legal informatics and in AI and law, we have both aspects, the rule and the concepts being represented through ontologies, through structure, we connect them, and the rule applying the concepts as defined in the ontologies. Recently, we have this machine learning approach where concepts have to be identified in the structures that emerge as a consequence of the learning of the learning algorithm. So we have this kind of a complex environment, and we have to look with curiosity towards the future to see what comes up next. So thank you very much for your attention.
Thank you very much, Giovanni. You know, the applause comes from the box, and we don't have that, so please be applauded by the audience, and thanks also for doing the summary yourself. It eases my jobs a lot. I may now start with questions. Ladies and gentlemen, please add your questions to the chat. I see. And here you see what's available. I see. Giovanni Culessa from Lutz University, impressive real work. Giovanni, thank you very much for sharing. And also from Stefan Eder. Can you elaborate on the example of Airbnb and how it is designed and how it may be used? A very difficult question, actually. But you know, he's the chair of the conference, and he gives challenges. Giovanni, please.
Now, can you repeat the question, because I'm not sure that I have understood. Sorry, Eric.
Yeah, Stefan Eder is a lawyer, and he knows Airbnb is some kind of a concept.
What was the last example you gave?
Sorry?
What was the last example you gave in this presentation?
Okay. It was the last example also in your presentation, actually. Yes, how to cope with this kind of Airbnb from a computational point of view, what it can offer. what is Airbnb, how you can
So it was
classify it,
whether
how you can...
So it was a question about the legal classification of Airbnb as is it a host provider or not? I think this is the question.
Airbnb is... Okay, maybe I'll...
Okay.
Let's say start maybe with some other questions and then come back to it because it's a bit tricky.
But maybe I
my
can
side,
say something on that. Sorry, Eric. Now, if the question is how to do, whether the concept of a host provider also covers Airbnb, in particular, whether it covers the information that is inputted by users concerning the guests or those who offer apartments on Airbnb. I think this exemplifies the kind of normative issues that we have in the law when we have to apply a concept. So the issue is, does the concept of host provider also cover Airbnb? It may seem that it is a kind of descriptive issue. Is a problem of classifying what is in reality, but the problem in reality concerns has to be seen from a teleological perspective. Do we want, or does it make sense from a legal perspective that also Airbnb enjoys the kind of immunities that host providers enjoy relatively to the information that is put online by their users? Or this is not the case because of the kind of economic activity that is done by Airbnb. So classifying Airbnb as a host provider or not would mean to include it or to exclude it from the e-commerce regulation. Now we have to see what comes up in the next Digital Services Act. If I had to say something for myself, I would say yes. I would think I would be in favor of applying also to to Airbnb the regulation of host provider. But this is a kind of legal argument, a kind of prescriptive or normative legal argument when you are arguing in favor of a certain interpretation. It is not, and this is the problem that we have with legal concepts. When making argument about a legal concept, we are not engaging with the structure of reality, we are engaging with legal issues.
Okay, Giovanni, thank you very much. We have one that's also interesting from Cécile Gouache, how you can model exceptions in ontology, and the other one is also interesting concerning sharing economy. If sharing is some kind of constituent element of a concept, how do you represent that? You see that you have this kind of sharing element, and you may then see that's also happening in many other concepts too, and you may then see what kind of legal rule may develop on that. Thank you.
Okay, how to represent exceptions? I think that there is a longer tradition on that, I think, with the feasible hierarchies, something that goes back to the 80s, I think, if I remember well. There were some, I don't remember now, I think Jeff Horty was one of those who developed the logics for the feasible hierarchies still in the 80s. And then, but today we have you cannot do that, I think, with description logics. You must use a kind of argumentation approach. And if you use an argumentation approach, you can represent conceptual definitions as kind of inferences that can then be countered by exceptions. I'm not so good in suggesting products, but I think this is the general idea, using an argumentation approach where you have the positive condition for the description of a concept, and then you have exceptions for not recognizing a concept, even in the presence of such positive conditions. So I would go for an argumentation logic in order to capture this kind of idea. You may use whatever there is the feasible logic. You may use other inferences for argumentation. You may even use Prolog or other similar tools which include a feature for dealing with the feasible reasoning.
Thank you, Giovanni. Yes, I'm also a practitioner, and therefore when you write something, you have to present some kind of an ontology, meaning you put everything of the rules in a conceptual structure. That's not so easy to do because you have to define concepts, you do relations, structures, and so on. And there's also some task that's done particularly by writers, also writers of commentaries, writers of textbooks, and also the argumentation for courts is a bit based on that, to define a nice conceptual structure. So how it can be helpful with this kind of new computational tools? So can I give you, say, that's a text corpus of 3 gigabytes, and please develop some nice ontology so you can argue before courts to find everything in a nice structured way? Is this possible now or a bit later? Thank you.
I think that there are various tools that can be used. For instance, I had the experience of interacting with presenting aviation law to technicians and to people working in aviation, and for that purpose we used a tool for drafting, for making argument graphs. And this way of communicating and structuring concepts were found to be very useful. I think that there are for what I can see, and the kind of tools that you can use in order to represent conceptual structures, you may have argument graphs. I would suggest are very useful, or you can also use tools for such as, I don't know, Protégé or other tools for representing ontologies, where you have different concepts linked by specificity or other relations. I believe that even for a practicing lawyer, it may be useful to have some kind of concept maps, some tools for drawing pictures of concept and of their relations. This, I think, is useful for organizing one's idea, the idea of the lawyer, and also for organizing his arguments. So these tools are not much used, but I think that there is we can make a case for them, and I think that in the future we will have them deployed to a larger extent.
When you see the textbook of an Austrian law student here in Vienna, it's marked, actually, highlighted with colors, mostly concepts, some ideas, commands. It's also some kind of putting some structure to this kind of textbook. So in our case, we use a lot of legal textbooks, but also then so let's say handbooks for learning law as such. So it seemed to be that also students try to do that, and I still remember the hypertext age when students used hypertext to develop some kind of structure, putting things together, establishing relationships. I guess that's a bit, early tools. Nowadays we have much powerful tools.
I would like to remind you also that the work of your colleague Friedrich Lachmeyer, who has devised various nice ways to represent in pictorial form legal concepts. So there is
right. It's, there's some others also. Karlik is doing a bit similar, also in a logical structure. Then some others in Germany use it for representing additional relationships, also in particular also Tobias Mahler, risk analysis, also Balgreen. Something you couldn't express easily in words. You can say there's relationships, there's risks. You can do it with using kind of graphics. And I may also ask, because there's some kind of computational tools, when you speak with technologists, they use a lot of unified modeling language and stuff like that, describe what they're doing, particularly in technology. But some tools may be also useful in law, some kind of describing what's happening. I guess Tom van Engels has used it for a while, I guess.
Yeah, in
So
my
this is another
experience,
tool that's quite powerful. Yeah.
no, I said that in this experience that I had, we used a tool that is called Rationale, which is a commercial product for drawing argument graphs, and we find it quite useful in modeling and an easy way without for representing concept without the need of having a computer background. So this was.
I have done a question from our good friend Michael Araskiewicz. Not sure if I understood it properly, but it's a bit like, how do you think it's correct to contrast the conceptual and the theological in legal reasoning? And also when it comes to concept, there is always some kind of a different element based on interpretation. You have the words, but you have also then the logical interpretation. You have a historical interpretation, and all everything may be then included in a proper conceptual representation. And I guess that's this idea, more of a theoretical one. How do you adapt to that?
Oh, thank you very much. This is this is a challenging question. But what I would like to say, just in this in this context, is that obviously you have the whole of interpretation that comes into play. What is important to remark with regard to formal models of legal knowledge, when we represent concepts and rules in a computable perspective, we must always, I think, consider the normative significance of concepts. While if you have to determine, I don't know, you are describing a kind of, you are developing an ontology for medicine or for technologies, you are doing a kind of descriptive analysis. You are trying to find the best way to capture the reality. When you are engaging in a legal ontology and you are linking your concepts to the terms of the legislator, for instance, to the term personal information as contained in the GDPR, you are engaging in a normative analysis because, as I mentioned before, if you say that a certain situation leads to a legal concept and this legal concept corresponds to the term used by the legislator, then you are arguing for whatever the legislator links to that concept. So if I am saying that evaluations are also personal data, then I'm arguing that evaluations trigger all the consequences that the GDPR links to the fact that piece of information is a personal data. You may process it only if there is a legal basis, the data subject has certain rights over it, and so on and so on. On the contrary, if evaluations are not personal data, then you have none of these consequences. So moving the including or excluding something from a legal concept triggers these legal effects. And here we have also the teleological reasoning that comes in, because you have to, in determining whether or not something falls or not into a concept, whether evaluations or not are personal data or not, I have to consider whether it is appropriate to consider them personal data, taking into account what follows from being a personal data, that all these legal consequences will apply also to evaluations. Okay, so I hope that this was helpful, even if I failed to answer the question by Michael.
Yeah, then from our colleague also in Poland, Joanna Kulesa, He's an international lawyer and human rights lawyer and also a specialist on ICANN. The UN processes, they have definitions, concepts, quite different from the national ones. How did you handle this? It reminds me also of my research in the 1990s when I tried to help international law, practice of international law to develop a bit using this kind of tools. It's a bit in this direction. So you have then many concepts, different concepts, and somehow you are asked to unify them a bit, to harmonize them. Can you help in that?
I don't think I can do much. Now, what I can say is that we have to distinguish, I think, the problem is that we have to distinguish the level of legal documents and the terms that occur in legal documents to the concept of the meanings that we ascribe to these terms. So I think that we have to recognize that the same term occurring in different legal documents, the international or the national ones, may have quite different meanings, and therefore I think that there is, and what meaning is more appropriate has to be determined in the context of the law that to which the document belongs. So I think that it would be a mistake to assume that every occurrence of a term in different legal, in different documents and in different legal system has always the same meaning. This is one of the criticisms that was raised against the so-called conceptualism in the, for many years, but we need to distinguish, I think, what is a term in a legal document and what meaning should we assign to that term. So I think we have to accept the idea that different terms may have different meanings. How to capture that at the level of an ontology? I think that ideally you should distinguish the concepts in the ontology for their textual realization and assume that different instances of the same text may be linked to different concepts. We cannot assume the ideal. No.
Okay, may I just to give you an example from the international law perspective? When I had negotiations with East Germany, GDR at that time, they didn't have the concept of the different concept of passports we didn't have. And that's particularly difficult in German, because then you have to use two different terms in the same documents. When normal relationships, they have two different languages, you just disguise it using the other language. I guess there's a lot happening there. And I guess should be developed so in some kind of structure. And to the passport, there's some rules. What this passport is actually, it's mostly a travel document giving identity. Now it's mostly paper, but in the future will be also an electronic form. So there may be then not only the passport, but also the laissez-passer from other organizations. Then you have some attributes. Nowadays, you have some visa attributes. Maybe in the future we have also corona attributes, saying I'm corona-free or not. I guess this is some kind of where these ontologies will move to have some kind, maybe some kind of a very general understanding worldwide, and you have some kind of a European one, a national one, and you also see the different attributes of these concepts, and it's a bit easier for the people also to use that. And there are other questions also from Jean-Baptiste saying, yes, when you didn't really come to an application that you use for Ross or some other application, say what to do with these concepts. I have only logical structures, the if-then structures with ECS. What to do with the concepts then, if there are different attributes?
Yeah, I think also in Austrian, you have the same term in Austrian law and in German law, but the term may not be, the meaning may be different because it reflects the different structures of the legal system. Or also we have same terms in the national laws and European law. For instance, the term in Italy, I think the term, if you are a trader, is quite different in Italian law from what it is a commerciante, from what it is in European law. So I think it's quite a pervasive aspect in the law that we can have the same term having different meanings in different legal systems.
But I guess these new tools can help to develop that, and also if it comes to jurisprudence, you may find out the different variations of the concept is applied by the judges by case law. So I guess that may be also helpful to support the practitioner, saying, yes, in case law we have this different conceptual structure, and you may learn that and use that for argumentation. In particular in areas where professors, writers are not so active. We don't have this kind of structure as required. So I guess that's some kind of a possibility. And just to refer back to this question on Ross intelligence, if you develop a system based on logic, what do you do with these kind of concepts if they have different conditions? You just include them, put them into rules or not? Sorry. But yeah, was it clear or not? Sorry, Giovanni.
Sorry, can you repeat? Sorry, I didn't understand. It was a question to me.
There's some tools available, like, for instance, the Ross intelligence, making your own system easily. And here, if the problem, you have concepts, and they have some kind of attributes. And how do you translate that into some kind of a rule-based structure when you say this if-then, and put it simply, in a simple form? But then you have a concept and you have different attributes to this concept. How do you propose how to handle this situation? You may have different attributes based on the legal system also.
I know this is an interesting issue. I don't have an answer, but I think that when lawyers of different systems interact, they have different conceptual structures, and we have to somehow to be aware of that and try to overcome the different. We speak of property from a common law, somebody from a common law, from a civil law country. There are different. We are referring to different legal institutes, but there is a core that overlaps. And I think that also with regard to computer systems that have been trained or have been modeled the law of different systems, we have a similar kind of issue when we are interacting with them. So this is linked maybe to the idea also of having explanation or being able to understand what such systems are doing, because if we cannot understand what is happening within them, the fact that we don't know where their concept come from, especially in the case of machine learning approaches, would make them really oracular for us. So I think this is really a challenge.
Thank you. From my side, a question also when it comes to judges, they have now the tools available that text can be easily developed, written down, so they maybe have some kind of document assembly systems, document information systems. The concept may be properly described as defined by the court, saying these components are necessary. So you use the definition again and again. That's happened in jurisprudence quite often, but now we have done better tools to use that. So do you think that this use of tool will make the concepts more stable? Also maybe that judges developed proper concepts at the beginning of work when it's a bit unclear, and then later they may reuse them again. A bit like back as in the concept jurisprudence, Begriffsjurisprudence in the 1990s, where they had developed this nice definition what the railway is. A definition about half a page was about 20 attributes or something like that. But I guess there may be a good development that a stronger use of concepts properly defined, also because it's important to do conceptual work, and maybe also that people are more used to conceptual work because of the tools, the attributes, the relationships, maybe better developed, and also from expect a bit more from law faculties that they may not put everything in text, also a bit more in conceptual structures. Maybe also in graphics like Friedrich Lachmeyer, maybe a bit easier understandable, usable, and also something that's reusable, because in ontologies it's quite nice, but when you say, yes, where can I buy an ontology in Austria, in Italy, yeah, the market is actually non-existent. There are some thesauri that's available in some countries, particularly with 2 or 3 languages like Belgium or Switzerland, Südtirol. They have ontologies, but otherwise they don't. The ontological work is still quite low. That's a bit the problem. And it's actually it's very hard work. You need a lot of resources, and normally it doesn't pay. There's in Austria some idea to develop an Austrian ontology, meaning some maybe about 5,000, 10,000 concepts properly described as all the relationships. That may come in the future, we'll see. It depends a bit on the cooperation between publishers and also legal authors. So far we have what's a bit common is this kind of books on legal concepts. So they have 5,000 concepts on public law and described for students mostly. But it will come, and I guess also the legal information system is also some kind of a good resource for an ontology. We can just by search seeing what kind of different versions of a concept exists. So I guess we do more on text in the future, and we look on the text from a conceptual way, but also from a logical way. So what's the logic behind, what's the concept behind? That's something we have tried to learn our students for a long time. And maybe with these new tools, they may do it in a more appropriate way and also see what's the logic behind, what's the theory behind this. I guess that's something quite important besides what we then do in machine learning, what we do with huge text corpora. We use similar tools, but for a much bigger purpose, actually. So I guess most as a law faculty, and we have to teach more about these tools and say students don't look at the text only, see what's behind. What is logic, what is concepts, what are interpretation, to make it easier to work with text. Because it's quite clear, text corpora will increase and the lawyers have to handle that. Computers may support them, but still the task is clear. Maybe you see it differently, Giovanni.
No, I agree with you. I think that in law we have the problem that these normative significance of legal concepts make it easy to have different people disagree on what is the appropriate scope for a concept. So we need to have our students, our lawyers, to engage in making explicit conceptual construction, but also to see them as something that is, I say, feasible and also flexible, so that it is okay to have different views about the best conceptual structure for a certain domain. I think it is important to see them as to see conceptual construction in the law as something that is provisional and depending on perspectives. But still, this does not exclude that we should build conceptual structures and link them to legal rules to reflect our understanding of the law, even though we may have different ideas on it. Yeah.
In Italy, at Torino, University of Turin, they are doing quite interesting work on putting together the European definitions and the national definitions of the same directive. So that's also a quite interesting work to see, and also the tools are now developed actually. And in another project we have developed some kind of an ontology, multilingual, and half of the work was done by the computer extracting the definitions from the various directives. So there may even more become on that. So Giovanni, thank you very much. I may refer you a nice book also.
Thank you very much.
On ontologies. So maybe someone will still read it, you never know. Legal informatics is not the bestseller so far, but it will come. And also, thanks a lot for being in this scenery for such a long time, because, every science needs people who have been here forever and know what's happening, both the people and also the books. And I guess that's a great value. And as I see, you're still quite engaged. and also you have good students, as I know, also with your colleague and professor Monica Palmirani. You're doing a lot establishing programs, summer schools in very nice sceneries in Italy. I guess that's important, just to achieve quality, because also what we see at the Research Meets Practice conference, the practice needs quality. If the tools are good, that's fine, then we will use it. If they're not good, we don't use them. And when you see the hype on legal tech, that couldn't solve it yet, but there's more money available. And yes, when we were poor science, and that's for a long time, you know, Giovanni, 30, 40 years, not much money, but still we developed our ideas and prototypes.
No, but now I think
published it.
I think that you know, I've been through the ups and downs of our domain, but now we are certainly on the upside. There is money coming in, there is a huge interest, so I think we should do our best to be on top of the wave as long as we can stay there. So
yeah, I agree, and we achieve, when it's referred to Stefan Eder, and he's a practitioner, quality decides. If the tool is good, I can use it, then we move on, otherwise not. And that's also the purpose of this conference, establish also standards, develop tools that are reliable, usable for the practice. So Giovanni, thank you very much for being with us, sharing your huge knowledge. And also for the others, yes, Giovanni is quite active, so he may, if you would like to come to Italy in summer, he offers some possibilities, combined science and also pleasure with some summer schools. And anyhow, you see at the websites at the European University Institute and the University of Bologna, just with a lot known to see. And Bologna is also a nice place to visit. So thank you, and hopefully there will be time that you come to Vienna and give a speech also here. Thank you very much, Giovanni.
Thank you very much, Eric. It was a pleasure being with you. Bye-bye.
Yes, now we have a break of 50 minutes. So we start again in 10 minutes past half, so at 4:40. So enjoy the break and do what you normally do in a break. And there's a possibility also, there is, let's say, there's an exhibition, that's a possibility. And also you can chat with each other. Maybe try.
There's a film by the Kunsthistorischen Museum.
And there's a nice movie from the Kunsthistorischen Museum, from the Museum of Arts in Vienna. Try it. It's great to have this exhibition in an online form. And I must also say that for today we will have also some music piece at the very end. And we doubled the team actually. So we will see, as a surprise, 2 people, and 2 people, more music, better music. So stay on, stay with us. Thank you.